In this video, we're going to be looking at freehold covenants. A freehold covenant is a promise made by deed, so in other words a covenant, between freeholders, whereby one party promises to do or not to do certain things. Now, let's make sure we know two key words. So we've got the covenantor, and that is the landowner making the promise, so that's where the burden lies. We've also got the covenantee. The covenantee is the landowner to whom the promise is made, so that's to whom the benefit lies. So a proprietary obligation. Covenants made between freehold landowners with respect to the use of land, so freehold covenants, are another way in which landowners may control the use of neighbouring land. So they are, in effect, a private model of land regulation. They are closely related to leasehold covenants and easements, each entail a benefit and burden in respect of two separate estates of land held by two different people. So we got to know that we got two pieces of land here, or two people, two pieces of land, one with the benefit and one with the burden. And that is very similar to what we will see in my later videos on easements and leasehold covenants too. So the nature of the freehold. The landowner making the promise on behalf of their land is the covenanter. So they are the person who carries the burden, the person doing something on the land. And the landowner to whom the promise is made is the covenantee, and their land receives the benefit. So it's really crucial that we understand these two key concepts of covenantor and covenantee. It's quite easy to get them mixed up, but we have this same sort of terminology all over the place in in law, with like contractor, contractee, leaseor, leasee, mortgagor, mortgagee, that sort of thing. A covenant is a promise made in a deed and as such is enforceable as a contract between the covenantor, the promiser, and the covenantee, the promisee, irrespective of whether contractual consideration is given. A restrictive covenant is an inherently equitable proprietary right, and so can be created by writing and signed by the conferring parties, and that's the Law of Property Act 1925, section 53. And covenants are usually made as part of the sale of land, and the covenant becomes part of the bargain of sale. However, they can also arise from a standalone transaction. So we got two different types of covenants. We got the positive covenant, and that's a covenant that sort of tells someone that they must take some sort of action, and a restrictive covenant or a negative covenant, which is that some party must refrain from some activity, they must not do something. And most covenants you will find are restrictive covenants. So covenants as interest in land. Most importantly, covenants are now clearly regarded as proprietary interest in land, albeit equitable in nature. So this means they have the following properties, which we shall now go through. The covenanter's land, the burden of the covenant. So the covenanter is under the burden of the covenant, and performance of this burden may pass or run with the land if certain conditions are fulfilled, but only when the covenant is restrictive. So that's the first attribute of a covenant as an interest in land. The second attribute, the covenantee has the benefit of the covenant. He has the right to sue for the performance of the covenant, and the benefit of the covenant may also run with the land in certain circumstances. Thus, this means that subsequent owners can enforce it. And covenants are proprietary, they're in rem rights, so it can impose benefits and burdens on the land so that any owner or occupier of the land may be affected by the rights and obligations of the covenant. When the covenant runs with the land, it attaches to the land itself and not to any particular person. So we've already looked at proprietary and rights in rem, so make sure you check out that video, because as I've always said throughout all my videos, those are the most crucial land law videos that you could watch, because they underlie all the different aspects of land law. And the other thing is the duality of benefit and burden. So usually the person benefiting or burdened by the covenant will almost always be the owner of the land so benefited or burdened. And before any covenant can be enforced, it must be shown separately that the benefit has passed to the claimant and that the burden has passed to the defendant. So that is the requirement of duality. So without this sort of duality, there can be no action on the covenant. Very importantly, do not fall into the trap of thinking that once you've made out your argument with respect to the benefit, that the burden follows, or vice versa. You must establish this duality. And so what is the relevance of law and equity when it comes to the enforcement of covenants? So equity led to the ability to give a remedy against a person other than the original covenantor. This transformed covenants from being purely contractual, so being purely legal, to being proprietary, giving a remedy at first in equity and occasionally at law. So at law, if a person sues at law, he'll be claiming that the defendant is subject to the burden and will claim damages. And the remedies at law, such as damages, are far narrower than you could get in equity. So not only is it easier to enforce a covenant in equity, but the range of potential defendants is much greater because the burden of a covenant may run with the land in equity in a way that is impossible at law. Also, equitable remedies are available. So we've got things like injunctions and specific performances are available. And importantly, it also seems that there may be a symmetry about the running of the benefit and the burden. So if the claimant is suing at law, he must establish that the defendant is subject to the burden at law. And if the claimant is suing in equity, he must establish that the burden has passed to the defendant in equity. This is particularly significant in the sense that it seems that in addition to the requirement of duality, there's also a requirement for symmetry in the way the benefit and the burden run. Not only must the benefit and burden have passed to each respective party, the claimant and the defendant, but they must have also done so along the same route, either by law or by equity. And just to finish off this particular video, I'm just going to quickly mention about the factual context for the enforcement of covenants. So, although we talk about freehold covenants, the rules relating to these covenants may apply between any claimant and defendant who do not stand in a relationship or privity. So freehold covenants do not necessarily relate to freeholds. This might include situations where a landlord seeks to enforce a covenant in a lease against a subtenant, or where a landlord seeks to enforce a covenant in an equitable lease taking effect prior to the 1st of January 1926. So that is the beginning and introduction to covenants. In the next videos, we're going to be talking about how you can enforce the covenant. And there's going to be a number of different principles to do with that and how we can pass the burden to successors in title and so on. So there's a bit more to go with regards to covenants, but I think this sort of introductory video was a good way to get started. Now, if you have any questions about this video, make sure you leave a comment below and I'll get straight back to you. And I would recommend that you subscribe because there'll be a new law video almost every day. Thank you very much for watching.